The subject of my lecture, suspect communities, as Ms. Graves mentioned, is especially timely in light of recent events. Like everyone else, I was shocked by last week's terrorist attack outside of Parliament. My thoughts and prayers are with the victims and their families and with the British people more generally. I am not an American official, but I am nonetheless confident in saying that the U.S. government and the American people stand with our British brothers and sisters. The United States and the United Kingdom are said to have a special relationship, founded on a shared language and a common early history, a brotherhood in arms during world conflagrations, and a commitment to political and legal liberalism. It is this latter point that I wish to emphasize. For at least a century, our two nations have stood together as modern exemplars of constitutional and democratic governance in the liberal tradition. Our nations share certain fundamental values, concepts, and rights, which have been challenged by political violence in our midst. Even before details about last week's attack were made available, British Muslims came under fire on social media, and as the details unfolded, the finger-pointing increased. In the city where I now reside, Birmingham, the Central Mosque has apparently experienced a surge in threats and messages of hate. More generally, Birmingham's Muslim community, which has long felt that it is under watch, has braced itself for what it sees as an inevitable backlash. In the words of one member of Birmingham's Muslim community, quote, "I've always feared the day Britain would be struck by a major terrorist attack again. This will make our lives much more difficult," unquote. Another member said this, "You cannot fight extremism by putting a community with its back against the wall." That latter sentiment, I believe, is surely correct. And in my lecture today, I'll begin by discussing how Anglo-American counterterrorism law has constructed the notion of suspect communities. I'll then explore the consequences of this phenomenon, which has been deemed racial profiling in the United States. My hope is that this will help us reflect upon our reactions to terrorist threats, particularly when an overwhelmingly peaceful community is the explicit or implicit focus of aggressive counterterrorism efforts. So let me begin with suspect communities in the United Kingdom. It almost goes without saying that terrorism has had a profound effect on English law. In particular, the Troubles would haunt generations of British and Irish citizens with spates of politically motivated bombings and assassinations. In response to these incidents, the United Kingdom enacted various pieces of legislation and engaged in executive policy making, including emergency measures to deal with the violent crisis in Ireland. Of note, in November 1974, a week after the bombing of two Birmingham pubs that killed 21 people and injured 180 more, Parliament unanimously enacted the Prevention of Terrorism Act, or PTA. This legislation, subsequent amendments, and related policymaking would become the foundation of counterterrorism law through the new millennium. Among other things, law enforcement established special interrogation procedures, indefinite detention, and non-jury trials for terrorism-related offenses through the so-called diplock courts. The UK government prescribed Irish organizations and made membership in them an arrestable offense. It also prohibited financial assistance and even public displays of support for such organizations. Law enforcement conducted warrantless and at times suspicionless searches, particularly at ports and other border controls. It also issued so-called exclusion orders against individuals that prevented them from being in Northern Ireland or Great Britain. All of this proved to be exceptionally controversial, hailed by some as necessary for the times and criticized by others as violating fundamental rights. Of relevance here, these measures had the effect of marking entire communities as suspicious, perpetuating discrimination against the community's members and exacerbating their disaffection. In his seminal study, Paddy Hilliard contended that counterterrorism efforts created a quote-unquote suspect community of Irish citizens living in the United Kingdom. A person who is drawn into the criminal justice system under the PTA is not a suspect in the normal sense of the word. Hilliard argued instead that people are suspect primarily because they are Irish. Quote, In attempting to prevent the spread of political violence to Britain, anyone living in Ireland, as well as anyone with an Irish background living in England, can be seen as falling within a category of people who may be legitimately stopped. The Irish community as a whole can therefore be legally viewed as a suspect community. According to Hilliard, law enforcement would rummage for information from anyone who was Irish or otherwise linked to Ireland, arresting those who had any connection to a purported terrorist, and then interviewing anyone connected to the arrestees, and then repeating the process until all potential leads were explored. Law enforcement would also engage in ad hoc interviews as a means of collecting further information about the Irish community and those connected with it. As a result, the police could bring into custody and interrogate anyone, irrespective of whether or not there was any evidence against them, because the principal arrest required no reasonable suspicion of an offense, Hilliard noted. The PTA essentially created a dual system of criminal justice, where murderers, robbers, rapists, and other, quote, ordinary decent criminals were dealt with through traditional criminal processes, while those associated with Irish terrorism were amenable to far less protective processes. Because the legislation and its enforcement could be seen principally directed at the Irish people, Hilliard deemed it an example of institutionalized racism. In the new millennium, parallels have been drawn between the experience of the Irish community under the PTA and that of the Muslim community under successor laws and policies. Of relevance here, a provision of the Terrorism Act empowers law enforcement in specified areas to conduct searches and seizures of persons and vehicles without individualized suspicion of wrongdoing, all in pursuit of articles used in the commission of terrorist acts. Another provision authorizes government agents to stop, search, interrogate, and detain people for hours at ports and airports without an individualized suspicion of wrongdoing in order to determine whether those people are involved in terrorist acts. The United Kingdom has also maintained some rather strict detention laws. Under the 2001 Anti-Terrorism Act, the Home Secretary could certify aliens that she suspected to be international terrorists and whose presence in the country she believed to be a risk to national security. Once certified, an alien who could not be deported could be detained indefinitely. After this provision was deemed invalid, Parliament enacted the Prevention of Terrorism Act of 2005, which allowed the Home Secretary to issue so-called control orders against both citizens and non-citizens suspected of involvement in terrorism-related activity. Among other things, control orders could involve curfews, electronic monitoring, searches of residences and other premises, restrictions on association, communication, and travel, and even relocation of an individual to another part of the country without their consent. When control orders were called into question by the courts, a new regime came into effect in 2012, the so-called Terrorism Prevention and Investigation Measures, the TPIM measures. This scheme is somewhat more constrained than its predecessors because it limits curfews to overnight, permits greater use of phones and computers, does not authorize forced relocation, and restricts access only to specific areas or places. British law also criminalizes various forms of incitement and association in the context of political violence. The Terrorism Act 2000 authorizes the designation of terrorist organizations and criminalizes assistance to those groups. Under the law, an individual commits a crime if he belongs to or professes to belong to, invites support for, or addresses a meeting of a prescribed organization. The Terrorism Act 2006 added provisions prohibiting encouragement of terrorism or the distribution of terrorist publications. With regard to encouragement, statements are presumed to be within the prescription if they glorify acts of terrorism, or if a reasonable person would understand that terrorism is being glorified as conduct that should be emulated by them. Under the law, it is irrelevant whether the statement relates to any particular act or whether it does, in fact, encourage another person. Now, all of these laws and powers have been applied disproportionately, if not exclusively, to Muslims in the United Kingdom. Let's turn to suspect communities in U.S. counterterrorism law. As is the case in the UK, the United States does not write on a blank slate when it comes to the topic of terrorism. During the previous century, the United States confronted periods of widespread fear known as Red Scares, the first of which originated from the jingoism of World War I and the subversive threat of anarchism and communism. In 1919, an anarchist group mailed several dozen booby-trapped bombs to prominent government officials and private citizens. Although the bombing sprees killed none of their intended victims, the incidents had a profound psychological impact on the populace. And in response to public clamoring for action, U.S. law enforcement launched nationwide raids targeting foreigners, particularly Russians and Eastern Europeans, to be searched, arrested, and eventually to be deported. These so-called Palmer raids, named after the Attorney General of the time, failed to turn up evidence of a plot to overthrow the U.S. government, but in the process, many people were swept up and deemed deportable based on the alleged possession of subversive materials or membership in proscribed organizations. The raids would be condemned as ruthless suppression. The scope of the effort, the poor preparation, and the abuse of the rights of those detained led to significant backlash against U.S. law enforcement. 2 decades later, during World War II, the U.S. government deemed individuals of Japanese descent to be a suspect community requiring mass detention, based on the belief that they were more likely to be disloyal to the United States and to commit acts of espionage or sabotage. The so-called exclusion of people of Japanese ancestry actually came in 3 separate steps. First, President Roosevelt issued an executive order broadly authorizing military commanders to exclude persons from certain areas, primarily Hawaii and the west coast of the United States. Second, Congress criminalized the violation of military orders issued pursuant to the President's authorization. And then third, military commanders issued orders setting curfews, authorizing detention, and establishing so-called relocation camps. The effect was that over 100,000 presumably loyal citizens spent the war years behind barbed wire in mostly desert encampments. Over time, the historical record would show that military officials had exaggerated the risk of espionage and sabotage, that they had withheld reports concluding that Japanese Americans did not present any type of unusual threat, and they generally relied upon grotesque racial stereotypes and mass hysteria. In ensuing decades, the internment order would be rescinded and convictions vacated, apologies would be given, and some relatively token remuneration offered, and the entire episode would be seen as disgraceful. To this day, however, the episode casts a pall over the government's use of race in assessing national security threats, and more generally, state actions that assume a predisposition to violence or criminality based on immutable characteristics or group caricatures. Now, although it is hardly akin to the Japanese internment, some post-9/11 policies and practices by law enforcement had ethnic or religious overtones as well. The targeting of Arab and Muslim Americans has resulted in a belief among Muslim community members that their rights are violated because of stereotyping and other forms of discrimination. In the immediate aftermath of 9/11, for instance, law enforcement interviewed thousands of individuals in a type of mass roundup. Government agents were instructed to, quote, use every available law enforcement tool to incapacitate suspicious individuals. With this mindset, law enforcement employed various means to detain suspects. Some were held on criminal charges related to terrorism. Other criminal detainees were charged with crimes unrelated to political violence, such as forgery or fraud or perjury or illegal weapons possession. Still others were detained under the so-called material witness statute, ostensibly to secure the detainee's testimony in a criminal proceeding. Others were arrested and detained for immigration violations. And indeed, federal law enforcement would arrest all individuals who were out of immigration status and treat them as being of interest in the 9/11 investigation, regardless of whether they were in fact connected to any lead. The tips resulting in arrests were often very general in nature, such as a landlord reporting suspicious behavior by an Arab tenant. In addition, the government instituted a special registration program requiring alien males from designated countries to report to the Immigration and Naturalization Service to be fingerprinted, photographed, and interviewed. All but one of these designated nations, that being North Korea, were Muslim-majority countries. The program registered more than 83,000 aliens, nearly 14,000 of whom were placed in deportation proceedings. According to a report issued by Amnesty International, many individuals from targeted immigrant communities fled with their families to the Canadian border to seek refuge from what they believed to be religious persecution. As for detentions, those accused of immigration violations, as well as some held on material witness warrants, were held for months on end, without trial or even access to legal counsel and their families, in various detention facilities around the United States. After the detentions began, allegations of mistreatment were reported in the media. Some claimed to have been placed in unusual conditions, like solitary confinement, and subjected to mistreatment because they were Muslim. A subsequent investigation by the Justice Department's Inspector General found a pattern of physical and verbal abuse by correctional officers. Among other things, some officials slammed detainees against walls, twisted their arms and hands in painful ways, stepped on their leg restraint chains, and punished them by keeping them restrained for long periods of time. Almost all of the aliens who were interviewed, detained, and deported were Muslims, or came from predominantly Muslim nations. And although subsequent guidelines issued by the Bush administration's Department of Justice generally prohibited race-based investigations, the rules allowed counterterrorism agents and airport security screeners to use race, ethnicity, and religion in their activities. According to some commentators, this exception essentially licensed discrimination against Muslims. In addition, law enforcement allegedly engaged in aggressive surveillance of Muslim communities, including the deployment of undercover agents and informants to infiltrate mosques. As for criminal prosecutions, law enforcement in the United States could draw upon an array of statutes oriented towards terrorism, many of them of relatively recent vintage. In particular, counterterrorism efforts have relied upon precursor crimes and offenses that target acts of support or encouragement, especially statutes that criminalize material support of terrorist acts or prohibited organizations, augmented by liability-extending doctrines and inchoate offenses like complicity, conspiracy, and solicitation. Relatedly, the government has employed strategies of pretextual prosecution and anticipatory prosecution. A pretextual prosecution involves charging terrorism suspects with comparatively minor crimes, for instance, immigration violations or fraud offenses, as a means of terrorism prevention. Disruption of plots with any tool available, while taking public credit for public safety, meant that law enforcement would label a wide variety of cases as terrorism prosecutions, regardless of whether they did, in fact, involve genuine acts or threats of terrorism. As detailed by Robert Chesney, anticipatory prosecution proceeds on an inchoate crime theory based on the harmful conduct that the government anticipates the person will commit. In describing one anticipatory prosecution, a federal judge noted that law enforcement had concluded that it was not for it to decide what offense the defendant had committed, but the government was satisfied that he committed some offense, whatever it is, for which he should be punished. In these cases, federal law enforcement has relied heavily upon undercover officers and confidential informants to expose what they believe to be latent threats. The trials are the result of a government strategy of preventative law enforcement, in which agents seek to identify not only individuals engaged in criminal activity, but those who, if approached with strong enough incentives, will agree to participate in terrorism. The combination of flexible counterterrorism laws and government-sponsored inducement have tended to create a danger that law enforcement has gone from detecting crime to creating offenses that did not otherwise exist. Though not explicitly based on ethnicity or religion, these terrorism-related cases certainly had a disparate impact on Muslims and people of Middle Eastern descent, leading to the perception of overzealous and prejudiced enforcement. Stepping back for a moment, it is unsurprising that suspect communities would arise in the context of terrorism, which has a certain gravity as it influences and at times distorts the subject matters that come within its orbit, including constitutional law, criminal procedure, the law of evidence, national security law, and even the law of armed conflict. Government officials have sought and to a degree achieved a type of terror exception to establish procedures and constitutional standards. Yet the concept of a suspect community is hardly new, and instead it represents a centuries-old problem, one that, as I said earlier, is termed racial profiling in the United States. Defined broadly, racial profiling is a term of art for the use of race, ethnicity, national origin, or religion to determine which individuals to detain and to investigate. Rather than policing based on individualized suspicion of wrongdoing, race or some other factor serves as a proxy for a particular offense or a crime in general, allegedly justified by a racial propensity toward a crime in general or towards a particular type of crime. This practice, in turn, rationalizes various forms of investigation of individuals of that race. Over the course of a quarter millennium, virtually every minority group in the United States has faced government prejudice pursuant to a type of equation of race. Dark plus different equals dangerous. In the late 20th century, Chinese railroad workers and laborers who had been brought to the western United States became easy scapegoats for increased crime and other social ills, and were subjected to discriminatory legislation and enforcement. A similar phenomenon occurred in the 1920s as Mexican immigrants who came to the United States to work in agriculture and manufacturing were vilified as a source of crime and violence. Some have suggested that racial profiling actually traces back to colonial America and the antebellum South, when blacks were subject to arbitrary searches and seizures to ensure against wayward slaves. Racial profiling continued after emancipation with the advent of so-called Jim Crow laws, and indeed it did not end with the fall of legal segregation in the United States. Interestingly, terrorism did inspire the prototype of the modern racial profile. Nearly a half-century ago, the U.S. government created the so-called hijacker profile in response to a spate of airline hijackings. At times, the hijacker profile became infected with racial or ethnic elements, and more generally, the hijacker profile had a very big problem. It didn't work. Although aviation officials eventually scrapped the profile in favor of electronic screening of passengers, the type of things that we go through now at airports, U.S. drug enforcement applied the underlying logic of the hijacker profile to drug interdiction at airports. Critics have argued that the resulting drug courier profile was so malleable and wide-ranging as to allow anyone and everyone to be stopped. Eventually, the profile spread beyond airports to law enforcement patrolling highways and streets. And some officials would even acknowledge that the use of race of law enforcement in these activities, that this supposedly rationalized the racial disparity in detentions and arrests because minorities were alleged to be the primary traffickers of illegal narcotics, for instance. Apparently, racial profiling became so prevalent in some African American communities that it received the tongue-in-cheek acronym DWB, Driving While Black. Other minority communities emphasized that racial profiling was not limited to African Americans in drug enforcement. For instance, Latino communities came to recognize their own interpretation, DWB, Driving While Brown, with Hispanic Americans living in border states alleging harassment by law enforcement agents in apparent pursuit of illegal aliens. These claims would be corroborated by empirical studies, concluding that minority motorists and pedestrians were being stopped at a disproportionate rate, even though minorities were not more likely to be violating the law. Now, most American academics who had written about racial profiling prior to 9/11 concluded that it was unlawful, it was bad policy, or it was both. And by the turn of the millennium, many politicians had gone on record expressing their opposition to racial profiling too. During the 2000 presidential election campaign, every major candidate explicitly condemned the practice. And in his first speech to Congress, newly elected President George W. Bush listed racial profiling as a top priority of his administration. He then ordered an assessment by Attorney General John Ashcroft, who said he was eager to stamp out racial profiling. This move triggered little dissent in national politics. By the turn of the millennium, it appeared that the United States had reached a political consensus about the existence and wrongfulness of racial profiling, which led to legislative bans on the practice as well as compulsory data collection and new police guidelines. But any semblance of agreement would end on September 11th, 2001. As mentioned, federal law enforcement proceeded to investigate thousands of Middle Eastern men now residing in the United States and detained hundreds of foreigners from predominantly Muslim nations. The government appeared to be engaged in racial profiling, and as it turns out, most Americans seemed to have no problem with the practice. Public opinion had swung suddenly and visibly to acceptance of racial profiling. Disturbing, for me at least, some academic commentators also demonstrated a change of opinion in favor of profiling. Interestingly, African Americans and Latinos, the precise individuals who had suffered most under the practice in the past, supported racial profiling when it was aimed at individuals of Middle Eastern descent. A new acronym was offered for this scrutiny, at least when applied at airports: FWA or FWM, flying while Arab or flying while Muslim. This brings us to the question of legality. Several lower court cases in the United States, both before and after 9/11, rejected race in search and seizure analysis. Of particular relevance, one court rebuffed the idea that Arabs have a greater propensity than non-Arabs toward criminal activity, namely terrorism. In reality, the problem was that the lenient standard of proof for stops and searches can provide cover for the use of race or ethnicity in determining those individuals to be investigated or otherwise placed under suspicion. In particular, racial profiling of blacks and Hispanics often occurs under the pretext of traffic stops pursuant to what has become an all-encompassing vehicular code. In 1996, the U.S. Supreme Court essentially put its imprimatur on the practice when it declined to inquire into an officer's motivations for a stop, so long as he had sufficient suspicion of some traffic violation, whatever it might be. Years earlier, the Supreme Court even condoned the practice of racial profiling in the immigration context, suggesting that Mexican appearance could be a relevant factor for immigration enforcement. Lingering still further in the background are the Supreme Court's decisions upholding the internment of Japanese Americans during World War II. Dissenting members of the court described the internment as falling into the ugly abyss of racism and violating a fundamental assumption of Anglo-American law, namely, guilt is personal and not inheritable. But although this episode of American history has been thoroughly discredited, the Supreme Court's opinions have never been overruled. And thus, in the words of Justice Robert Jackson, they lie about like a loaded weapon ready for the hand of any authority that can bring forward a plausible claim of an urgent need. And indeed, the precedent was invoked in 2015 by the mayor of my former hometown as a rationale for suspending assistance to Syrian refugees. Even if we assume the use of racial profiling is legally permissible, there are good reasons to reject the practice. To begin with, racial, ethnic, or religious stereotypes are notoriously inaccurate, given that the number of offenders within a large racial, ethnic, or religious group will constitute a small fraction of the total population, and thus cannot justify throwing a blanket of suspicion over an entire community. Studies have shown that the use of racial appearance in deciding whether individuals should be targeted for detention, searches, and questionings is a highly effective form of crime investigation. Seen as an issue of hit rates, the odds that the police activity will generate contraband or weapons or evidence of other crimes or arrests, things like that, racial profiling does not increase the productivity of law enforcement. Rather, the use of race or ethnicity has a lower hit rate than police activity free of racial profiling, police activity that focuses on behaviors. In the 1990s, for instance, the U.S. Customs Service eliminated the use of race in its detention and search decisions, relying instead on a list of suspicious behaviors. And as a result, the rate of uncovering contraband and illegal activity increased more than threefold. As is the case with other forms of racial profiling, singling out threats based on immutable characteristics, such as race or ethnicity, in terrorism investigations can be notoriously inaccurate. Again, the vast majority of Muslims, literally millions of people in the US and in the UK, and billions of people around the globe, are thoroughly law-abiding and present no threat to national security. For instance, of those 83,000 aliens that were registered by federal law enforcement in the United States after 9/11, not a single one of those individuals were ever charged with a crime of terrorism. The same is true of profiling in other national security contexts. The vast majority of Irish individuals detained pursuant to the PTA were subsequently released without any action taken against them. And then there is the World War II detention of more than 100,000 individuals of Japanese descent. Less than a dozen individuals were convicted of spying for Japan during World War II, and none of them were of Japanese or even Asian descent. A second reason to reject racial profiling. The conditions that lead to the creation of suspect communities often prompt government officials to take swift and severe actions which depart from ordinary standards of due process. As noted by Kent Roach and Gary Trotter, societies dealing with terrorism and the fear of terrorism are liable to forget not only that past anti-terrorism laws have not made them safer, but also that they have contributed to miscarriages of justice. Several decades ago, the United Kingdom suffered a spate of wrongful convictions arising from the Troubles. The cases involved actual or threatened bombings and were prosecuted in an environment of public angst over terrorism by the Irish Republican Army and other groups. One prominent British jurist even suggested that it would have been better if the defendants had been hanged in the so-called Birmingham 6 case. Although the innocent might be punished, Lord Denning said, quote, "the whole community would be satisfied," unquote. Eventually, the Birmingham 6, as well as the Guildford 4 and the Maguire 7, would be released out of concerns for what are now known to be the common causes of wrongful convictions: false witness statements, unreliable confessions, bogus expert testimony, misconstrued facts, undisclosed evidence, and so on. Still, other problems were related to the seemingly martial nature of the conflict in Northern Ireland. Information used against a suspect might involve national security information deemed too sensitive to reveal to the defendant, or it might take the form of data from intelligence, raw data from intelligence surveillance, both domestic and military, with the information often arriving in layers of hearsay and perhaps some unsourced judgments. A post-mortem report on one of the cases acknowledged that decision-making was affected by the ethos of fear and belligerence, such that, quote, "the context of the prevailing bombing campaign and the atmosphere of the trial made it impossible for them to make a wholly objective and dispassionate appraisal of the admissible evidence alone," unquote. The United States has experienced similar concerns in some of its counterterrorism cases. In fact, the very first post-9/11 trial provides perhaps the best example of terrorism prosecutions gone wrong. The prosecution's theory of the case was that the defendants were a sleeper cell of an Islamist terrorist organization, and it resulted in the conviction of 3 men living in Detroit. President Bush listed the case as an example of law enforcement having thwarted terrorists, while Attorney General Ashcroft hailed the prosecution as a major victory in the war on terror, and it was noted in a report to Congress as one of the Justice Department's notable achievements. But the case began to unravel post-trial as the government revealed numerous documents that were never provided to the defendants. In granting the defense motion for a new trial, the district court said, quote, "the prosecution early on in the case developed and became invested in the view that the case and the defendant's culpability and the role as to the terrorism charges, and then simply ignored or avoided any evidence of information which contradicted or undermined that view. When viewed against the backdrop of September 11th attacks against our nation, the public emotion and anxiety that has ensued, the prosecution's understandable sense of mission and its zeal to obtain a conviction overcame not only its professional judgment, but its broader obligations to the justice system and the rule of law." A third concern relates to racial injustice and its impact on cooperation with law enforcement. Consider the context in which many minority citizens and law enforcement interact on a daily basis today and in the past. Minorities perceive harassment at the hands of law enforcement as a burden of their lives. Much of it comes in the form of racial profiling and the humiliation that accompanies this practice, the violation of personal privacy, the embarrassment of being fingered as a potential criminal, and the injury from recognizing that one's skin color is the basis for that harassment. Harvard Law professor Randall Kennedy described race-based policing as a kind of regressive tax on minorities in service of criminal and immigration policy, where that tax is the cost of being subjected to greater scrutiny than others. Given that minorities are often bound together through the concept of linked fate, an evaluation of individual welfare based on the treatment of other members of their community, the perceived abuses form a basis for racial solidarity against law enforcement. A number of antisocial consequences then ensue. Social studies have shown that the appearance of fair, equitable procedures affects both the perceived legitimacy of government and individual citizen behaviors. Leading social psychologist Tom Tyler has shown that there's a two-step mechanism where people's judgments about the justice or injustice of their experience affects their view about the legitimacy of the authorities. And those views, in turn, shape compliance with the law. Conversely, perceptions of procedural injustice undermine the perceived legitimacy of the law and its enforcers, which in turn reduces public compliance with legal commands. Racial injustice thus imposes very real costs on a criminal justice system. Members of distrusting communities will shy away from cooperation with law enforcement, withholding valuable information or creative solutions to social ills. In addition, community members may feel less likely to obey legal commands. Police motives, police legitimacy, and procedural fairness become subject to challenge, and in the end, the law may simply be ignored. Indeed, this environment may transform criminals into heroes and martyrs and result in the celebration of an anti-police, pro-crime culture. All of this comports with Professor Hilliard's view that the use of counterterrorism provisions primarily against Irish suspects and their families and their friends both reflected and intensified anti-Irish prejudices within elements of the British public, and therefore further alienated the Irish community within the United Kingdom. Other scholars have suggested that heavy-handed execution of purportedly emergency legislation in Northern Ireland had the counterproductive effect of generating support for, or at least acquiescence to, the operation of terrorists within the community's midst. Recent works have also confirmed the correlation between perceptions of procedural justice and both perceived legitimacy and the willingness to cooperate among Muslim communities in counterterrorism efforts. The creation of this new suspect community, when subject to racial profiling in the pursuit of purported terrorist threats, appears to have a substantial negative effect across Muslim communities in both the UK and the US. The perception of anti-Muslim profiling, coupled with overzealous programs of government surveillance, have tended to undermine the confidence of Muslims and Middle Eastern communities in law and its enforcement. As David Harris, a leading racial profiling scholar in the United States, has said, if there is a danger of international terrorists striking us on our own soil, and if, as some allege, the most likely suspects would be persons who either come from or hide among communities of Arabs or Muslims, there is only one real source for the critical intelligence we need to keep ourselves safe: Arab and Muslim communities themselves. The use of racial profiling jeopardizes all of this. Ultimately, though, I believe the best reason to reject racial profiling and eschew the creation of suspect communities is normative, not empirical, namely our shared commitment to the rule of law and individual rights. In its Anglo-American form, the rule of law checks arbitrary authority and protects all citizens. By choosing the rule of law over the rule of men and declaring the former supreme, a liberal society announces a preference for personal liberty, achieved by placing legal limits on the conduct of government. This liberty allows each individual to live in confidence that if he obeys just laws and respects the rights of others, he will not be subject to the coercive power of government. This distaste for arbitrary authority and the accompanying commitment to rule-based judgments also supports the rule of law's aim in equality of treatment. For state action to be consistent with this goal, like cases must be treated alike, and similarly situated people must be subject to the law and its enforcement, including government authorities themselves. Locke equated freedom with laws common to every one of that society, while Montesquieu saw the force of the law as consisting only in its being enacted by everyone and for everyone. By demanding universality in legislation and consistency in application, the rule of law ensures that officials will not single out particular individuals or groups for unfair treatment or special privileges. The rule of law thus comports with what we might term reversibility or reciprocity, the notion that the law should be enacted because of its salutary effect for society as a whole, and not for the personal benefit or detriment of some. Decision makers must view themselves as both the author and the addressee of an action. So when thinking about racial profiling in suspect communities, we should ask ourselves whether we, as Christians or Jews or atheists, would be willing to subject ourselves to heightened scrutiny precisely because of our faith or our lack thereof. The prevention of tyranny has also been sought through guarantees of various rights beyond those subsumed within the concept of the rule of law, all intended to inhibit abuses by the state. The liberal tradition of individual rights extends back in history through momentous events limiting the power of government and the seminal scholarship of the Enlightenment, to the ascendancy of Western and specifically Anglo-American notions of justice. When we call anything a person's right, J.S. Mill declared, we mean that he has a valid claim on society to protect him in the possession of it. Critical to this understanding of rights is their counter-majoritarian function, to prevent a tyranny of the majority, where those empowered by their sheer multitude or position can unfairly extract resources and otherwise oppress individuals and disfavored groups. The true measure of a right in a liberal society is not the security afforded the multitude, whose interests are typically preserved in the democratic process, but instead the protection it provides the lone individual or minority groups who stand in the majority's way. In Anglo-American law, for instance, individuals have the right to be free from arbitrary deprivations of their privacy and liberty, thus requiring law enforcement to provide appropriate justifications for any searches and seizures of their persons and their property, often in the form of judicially approved warrants, supported by individualized suspicion of crime and authorizing delimited actions by government agents. Underlying each right, there is a history, often tinged with government oppression. For instance, the U.S. Protections regarding searches and seizures were premised on a history of abuses by the British Crown through the use of instruments known as general warrants and writs of assistance. General warrants in England commissioned officers to ransack homes and businesses at their discretion, to search and seize the literature of religious dissenters and publications allegedly amounting to seditious libel. In the American colonies, the writs of assistance permitted customs agents to search at large for smuggled goods without the limits on place and duration. The former were declared unlawful in a pair of famous British cases, while abuse of the latter, more than any one single factor, gave rise to American independence. The question to ask ourselves is whether the investigation, detention, and search of individuals because of their membership in a community is altogether different from a modern-day general warrant, or whether it constitutes a type of racial writ of assistance. Again, thank you for inviting me here today. I look forward to hearing your questions and comments, and I appreciate the opportunity to be here at Gresham College. Thank you.